Friends, today's topic is execution. We are having dispute with so many persons in our business transactions, and one takes the things what is unable to do his liable duties that he does not pay the amount. So we go to court under civil suit and get the decrees as per our documents in our favor. That I mean to say we are judgment creditor. And after doing all this, we need to do execution of the decree. As automatically things does not happen if the party is not of good reputation. We have to take the help of court again. So, what is execution? We will discuss in this video what is the concept and general principles of execution. If we go by CPC, there are sections from 38 to 46 which deals with general principles of execution. What is execution? Execution is the medium by which a decree holder compels the judgment debtor to carry out the mandate of the decree or order as the case may be. It enables the decree holder to recover the fruits of the judgment. The execution is complete when the judgment creditor or decree holder gets money or other thing awarded to him by the judgment, decree, or order. Now, coming to execution meaning, the term execution has not been defined in the code. The expression execution means enforcement or implementation or giving an effect to the order or judgment passed by the court of justice. Simply, execution means the process for enforcing or giving effect to the judgment of the court. Execution is the enforcement of decrees and orders by the process of court, so as to enable the decree holder to realize the fruits of the decree. The execution is complete when the judgment, creditor, or decree holder gets money or other thing awarded to him by the judgment, decree, or order. I have repeated these paras twice so that you may know what our topic is. For example, I am having some debt against Mr. Dhanua. I file a suit against Mr. Dhanua for the said amount and obtain a degree against him. Here I am the degree holder and Mr. Dhanua is the judgment debtor. And the amount whichsoever is due is the judgment debt, or you can say decretal amount. Since the decree is passed against Mr. Dhanua, he is bound to pay the stated sum to me. Suppose, in spite of decree, Mr. Dhanua refuses to pay the amount to me, then I can recover the said amount from Mr. Dhanua by executing the decree through judicial process. Now I am discussing one case law, that is Ghanshyam Das versus Anant Kumar Sinha. Supreme Court in this case, while dealing with the provision of code relating to the execution of decree and orders, and Honorable Court stated, so far as the question of executability of decree is concerned, the Civil Procedure Code contains elaborate and exhaustive provisions for dealing with it in all aspects. The numerous rules of Order 21 of the Code takes care of different situations, providing effective remedies not only to the judgment debtors and decree holders, but also to the claimant objectors. there are so many claimants. They are saying that we are also having some amount against the judgment debtor, and he has plied this property to us. So they are known as claimant objectors. Or as the case may be, in an exceptional case where provisions are rendered incapable of giving effect to an aggrieved party, then the answer is a regular suit in the civil court. Now, when we have to take the help of court, first is the application. So we start with the execution process by giving application for execution of degree. So all proceeding in the execution commence with the filing of an application for execution. Who can give application for execution? First one is degree holder himself. Second one is legal representative of the degree holder. Third one is representative of the person claiming under the degree holder. And last, transferee of the degree holder. But in some cases, now coming to general provisions of execution, that is section 38 to 46. What the section 38 says, its heading is code by which degree may be executed. We have to give application which court has the power. So decree may be executed either by the court which passed it or by the court to which it is sent for execution. Now coming to section 39, that is relates to transfer of decrees. The court which passed decree may, the wording is may on application of the degree holder sent it for execution to another court of competent jurisdiction. If the person against whom the decree is passed actually and voluntarily resides or carries on business or personally works for gain within the local limits of the jurisdiction of such court, other court, okay? Or second situation can be if such person has not property in the local limits of the jurisdiction of the court which passed the decree, that is sufficient to satisfy such a degree, and has property within the local limits of the jurisdiction of such other court where the degree is being transferred. Third situation is if the decree directs the sale or delivery of immovable property situated outside the local limits of the jurisdiction of the court which passed it. And second one, fourth one is if the court which passed the decree considers for any other reason which it shall record in writing that the decree should be executed by such other court. The court which passed the decree may of its own motion send it for execution to any subordinate court of the competent jurisdiction. Now coming to section 40, its title says transfer of decree to courts to another state. Firstly, we discussed within the state parameter, and now to another state. Where a decree is sent for execution to another state, it shall be sent to such court and executed in such manner as may be provided by rules in force in that particular state where a decree is sent. Section 41 deals with a result of execution proceeding that is to be certified. The court to which a decree is sent for execution shall certify to the court which passed it the fact of such execution, or where the former court failed to execute the same, the circumstances attending for such failure are to be explained. Now, section 42, it deals with power of the court in executing transfer decrees. The court executing a degree sent to it shall have the same powers and executing such a degree as it had been passed by itself. All persons disowning or obstructing the execution of the degree shall be punishable by such court in the same manner as if it has passed the degree, and its order in executing such a degree shall be subject to the same rule in respect of appeal as if the degree has been passed by itself. The power of the court under this section shall include the following powers of the court pass, pass the degree, namely, power to send the degree for execution to another court under section 39, power to execute the degree against the legal representative of the judgment debtor under section 50, power to attach order attachment of the degree. A court passing an order in exercise of the power specified shall send a copy thereof to the court which passed the decree. Now coming to section 43, execution of decrees passed by civil courts in places to which this code does not extend, then what to do when this code does not apply? The solution is any decree passed by any civil court established in any part of India to which the provisions of this code do not extend, or by any court established or continued by the authority of the central government outside India, may, if it cannot be executed within the jurisdiction of the court by which it was passed, be executed in the manner herein provided within the jurisdiction of any court in the territory to which this code extends. So it can be transferred where this code extends so that effectiveness of the execution is achieved. The other sections are Section 44, execution of decrees passed by revenue courts in place to which this code does not extend. The similar provision is for revenue courts. And then Section 44A, execution of decrees passed by courts in reciprocating territories. There is arrangement in foreign countries where we are having reciprocatory arrangements. So both sides cooperate in execution of degrees. If they are applying to our country, our district courts execute, and if we are sending the degree for execution there, they are executing as per law. Then comes section 46. It talks of precepts. Upon the application of the degree holder, the court which passed the degree may, wherever it thinks fit, issue it with a precept to any other court which would be competent to execute such a degree to attach any property belonging to the judgment debtor and specified in the precept. So whensoever the degree is transferred for execution, there is detail of the property which is ordered to be attached and amount of creditor is received through the sale of that property. So when this precept is sent to the another court, the court to which the precept is sent shall proceed to attach the property in the manner prescribed in regard to the attachment of property in execution of degree. As far as time limit within which we can give application, there I am covering in my next video. Up till now, thanks for watching. Jai Hind. What I request, if you want more subject to be covered, you can call me. My cell number is 9888 072363. Thank you for watching.